And let's go ahead and get started. It looks like we have a good group. So hi, everyone, and welcome. My name is Allison Held. If I don't know you, I'm the director of the Medical Legal Partnership at VCU, and we are just delighted to be able to host this webinar today on education advocacy and hope that you all will find it helpful. As you may know, unfortunately, we are at capacity right now for education referrals. So we are planning to add a new legal partner soon. So we hope to be able to take these referrals again in a few months. We will definitely let you know as soon as we can. But for now, we hope that Cassie's presentation and the resources that she provides will help you and your team members advocate for your patients and families, and also help families advocate for themselves. Before I introduce Cassie, just a couple of housekeeping items. As we were just talking, please put your...
Allison, we lost you.
Oh, no. Can you hear me now?
Yeah, you're back.
Okay, I'm sorry. Molly is going to take over. I have been having some internet problems. So if that happens again, Molly, I might ask you to jump in. I was just asking everyone to put your questions in the chat, and I'll monitor that. We are recording the presentation and we'll distribute it along with Cassie's slides to everyone on the invite sometime next week. So if any of your colleagues weren't able to join us today, they can watch the video. And then last thing, if you all could just mute your microphone so we don't have any background noise, we'd appreciate it. And now I would like to go ahead and introduce Cassie. Cassie is the managing attorney of Virginia Legal Aid Society's Suffolk office, where she leads a team serving families and individuals with limited incomes in a broad range of civil legal areas, including housing, public benefits, domestic violence, and education law. She previously worked as an attorney with the Legal Aid Justice Center's Youth Justice Program, focusing on education and civil rights law. And she earned her dual law and Masters of Social Work degrees from the University of Richmond School of Law and VCU. And she earned her undergraduate degree from the College of William and Mary, where she received the President's Award for Service. So we are very fortunate to have Cassie with us today to present on this topic. Cassie is also just a really lovely person, has been so kind to us and has been a tremendous resource to us over the years. She trained most of, if not all of the attorneys who handle these cases for us. And she continues to serve as a subject matter expert and resource for the MLP and for all of our patients and families. So Cassie, I will go ahead and turn it over to you.
Thank you so much, Allison, and thank you so much for your leadership with the MLP. This is one of the topics that I am most passionate about, and so I'm always happy to talk about it and to provide any feedback and guidance I can. I really appreciate the work of the MLP. As you all know, this is such an important area, and we see families all the time who are struggling with it so much, and so I'm always happy to talk about it. I know firsthand the frustration of having a parent in front of you who is struggling with advocating for services for their child in the school and not having enough resources to be able to support them in that, and also needing something concrete to be able to tell them to give them some next steps. So my hope is that this is as useful as possible. I'll note that I could talk about this for a week and still probably not cover everything that you might need to know in any particular scenario, but my hope is that this is as useful as possible. I tried to get rid of some of the legal jargon and just focus on the things that are most important. So before beginning, I did just want to make a very quick plug for legal aid. I've worked as a legal aid attorney my whole career, and not all legal aids in Virginia do education law. Some of us do, but I did just want to make sure that folks know that if you have a family who is experiencing a civil legal issue and they have limited incomes, that legal aid may be a good resource for them, particularly if they're facing an eviction or they're having an issue with their public benefits. Legal aid is always a good resource to try to look at. So just a quick plug there. So some of the topics that we'll cover: special education, school discipline, and then some other education issues. Allison mentioned that several folks had questions about bullying and how parents can address their children being bullied in school and what things that parents can do. Also some things that I see a lot and you all may see, issues with language access, issues with children who are experiencing homelessness, and then also issues with parents having issues getting their child's education file and their right to see their child's education records. Those are some issues that I frequently encounter, and so included those and in the hopes that it would be useful to you all as well. So just starting with special education. So I wanted to start with a couple definitions because I think that when you as a stakeholder or when you're talking with parents about this, when a parent is in an IEP team meeting or an eligibility meeting, they're going to encounter some definitions that are going to be unfamiliar, and you might encounter definitions that are unfamiliar. And so I think it's good to have a really basic understanding of a couple of definitions that you'll encounter throughout the special education process. And then I'll focus more on the tips, but do want to get some of the legal jargon out of the way. So the Individuals with Disabilities Education Act is the federal law that that basically dictates what affirmative duties schools have for children with disabilities. So IDEA requires that all schools who receive federal funding provide children with a free and appropriate public education, or FAPE, sometimes via an individualized education program, or IEP. So FAPE has a particular definition. It's designed to ensure an IEP, an individualized education program, has to be designed to ensure that that child makes meaningful progress in school. And that is the definition that courts have come up with to make sure that that child's making meaningful progress. So I see often, and I know you all have seen times where a student is just being funneled grade to grade to grade to grade, and they are not making meaningful progress. And what I argue in that instance as an education advocate is that they are not receiving FAPE. They're not receiving the appropriate services that allow them to make meaningful progress on their education goals. Schools also have an affirmative duty to identify, locate, and evaluate all children with disabilities. So that means that they have the affirmative duty to find children who have disabilities and to make sure that they're receiving the appropriate services. In practice, I know, and I'm sure you all have seen, that it's very helpful, of course, if parents assist in that process and other stakeholders. So if a school has missed a child who is having some issues, they're struggling in school, there's some things that parents can do to ensure that the school's child find obligations are triggered and that they are completing that evaluation process. And we'll talk about that. Schools also have an affirmative duty to educate children in the least restrictive environment. So if that means that if children can be educated with students in the general education classrooms, then they should be. However, it should not be used to deprive students of more intensive services if that is what they need. So LRE is basically, it's a rule designed to make sure that we're not isolating kids with disabilities, but also to make sure that they're getting the services that they really need. And finally, IDEA requires that schools involve parents in decision making. So parents are really important stakeholders in this process. Again, I wanted to make this as useful as possible. So I am sure this is an example that you all see many, many times in the MLP. You have a child who comes in through the MLP. They're clearly struggling, or that you see in your practice, they're clearly struggling in school, but they don't have any special education services. And the parent has expressed some concern about the, sorry, I think.
We share in your grief. You have our.
I think somebody has their mic on. Allison, I'm not sure if you can mute them as well as the host.
Basically treasure and honor the fact that we have to help them.
Yes, I am working on that.
4 years. Yeah. You know, it was.
I can't tell who that
It's
is.
a gift to be in somebody through the scariest phase.
It's a phone number of 5257.
In a way where they can be appreciated.
Okay.
So, like, would you say anything like we're confident, like, that you guys say, like,
Sorry, Cassie.
Oh, no, not at all. I understand.
I'm just
Sometimes
not,
this is me.
okay, I think I muted them.
Okay. But yeah, so this is an example that I imagine that you might see often. You have a child who is struggling in school. They don't have an IEP. They don't have a 504 plan or anything right now. The parent has gone to the school. They've told them like, hey, I'm kind of worried about this child, my kid. I don't know what they need, but this isn't quite working. And the school's just not really responding to that. And so this parent has now come to you and told you, well, this is happening. What do I do? And so what do you tell her? What do you do in that situation? My recommendation is to send a request for evaluations for special education in writing and to keep a copy. And I've included the specific suggested language that I would use. Sometimes parents will send an email saying, he's struggling, I don't know what to do. I think it shouldn't have to be this specific, but I think something like this is specific enough that it should trigger the school's obligation to, or it does trigger the school's obligation to at least hold a meeting to determine whether or not they're going to evaluate that child for special education services. So feel free to copy and paste this text directly. I'm going to send my presentation to Allison after the meeting, along with some other resources that I think might be useful to y'all. So don't worry about writing this all down. You'll have a copy of it, but feel free to use this and share it with parents that need to request special education services. It's a simple one. It's fill in the blank. Folks should be able to use that. But I definitely recommend sending a request for evaluations. And again, this triggers specific obligations on the part of the school. So the school, once they receive this, they have to decide within 3 days whether or not they're going to schedule a meeting, go ahead and evaluate the child, or deny the request. And then within 10 days, if they decide to schedule a meeting, they have to hold that meeting within 10 days. So this is a fast moving process. There are timelines that this triggers. And so this is a good thing to have in your pocket when you're advising parents what to do. So when we're talking about, okay, so we think this child needs help in school. We think they might need some special education services. The school is going to evaluate them for special education. What does that mean? And what does that look like? Schools must evaluate in all areas of suspected disability. I imagine that you all do some evaluations of your own in your fields and the things that you're doing. The evaluations that schools do are separate. They have their own personnel that are doing their own educational evaluations. There's particular evaluations that schools are generally going to do through this process. It usually involves an educational evaluation, a psychological evaluation by the school psychologist, a sociological evaluation by the school social worker, an observation, and then a medical evaluation. So these are the evaluations that the school might do. So they've had the meeting. They're like, okay, we're gonna go ahead and evaluate this children for services. Here's the evaluations that we're going to do. The parent can request additional evaluations be done. So say, for example, you have a child who has dyslexia, and this is a child who may, you think might need some additional services. Maybe they need OT support because they're having trouble writing or something like that. You can request that child also receive, or the parent can request that child also receive an occupational therapy evaluation or an assistive technology evaluation. There's other evaluations that parent might consider requesting. And this is actually something where I think you all can be particularly helpful to parents, is helping them understand the different evaluations that their child might need and helping them craft the reasons for why that evaluation might be needed. So that's something that is important knowledge that you all might have that would be very, very helpful. And as I'm thinking of it, would be helpful to me as I'm thinking through, various things that children might need, but you have particular expertise that I think might be helpful in this situation. So that's the evaluation process. I will note that some of you might be wondering, well, what about the evaluations that I do that are separate from the school's process, and how does that come into play during this process? And I'm going to get to that. So don't worry, I'll touch on that too. So there is a list of disabilities under the IDA. So when we're saying we're going to evaluate that child for special education services, what the school is actually doing, or the eligibility team is doing, is determining whether or not that child has an educational disability that adversely affects their educational performance. And then due to this, they require special education services. So as part of the definition for whether or not they need special education services, they have to have a certain disability under IDEA. There's 14 different disabilities categories that are listed under IDEA. I've listed them all here. I won't go into all of them, but I did just want to flag two in particular. One is, sorry, that's my cat, Norman Bates, who is living up to his name and being jerky, as I told my husband he would. So the first is developmental delay. Developmental delay is not available for people who are for children who are 7 and above. If you're 6 and under, you can have that categorization, but it stops at age 6. The other one is other health impairment, and ADHD and other disabilities are included there. There's a number of different disabilities that are included there. So these are the list of categories that the school is going to be looking at to see whether or not a student has an educational disability and therefore may be eligible for special education services.
Can I ask you a question? There's a question in the chat while we're talking about. The question is, if a parent thinks their child has dyslexia that's undiagnosed, what evaluation should she ask for?
That's a really good question. I think an educational evaluation is good. I would also be sure to look at the students' records and handwriting and reading evaluations. So any sort of reading tests that they've done, any kind of reading tests that they've done, looking at their educational evaluation, looking at their handwriting, all of that should point to a diagnosis of it's hard to pinpoint exactly what it is. Is it dyslexia, or is it, a cognitive issue? Is it something else? Is it dysgraphia? Exactly kind of what it is. And so I think having those multiple evaluations, the OT evaluations, the reading evaluation, the educational evaluation, and really looking at how that child reads, how that child functions in school is going to be really important. And I think having a reading specialist in the eligibility meeting is important too. So having someone with that particular expertise in the eligibility meeting, I think is important. And I think the parent should ask for that.
Thank you.
Yeah, no, thank you. And please feel free to interrupt too as more questions come in. I'd love to try to answer those as they come. So feel free to stop me.
There is one more that just came in, Cassie.
Yeah.
So in the case of an identified diagnosis, for example, ADHD, autism, if the child is currently performing, quote, adequately per the school's performance measures, is there an obligation to provide support services, or do the families have to wait for a decrease in academic performances to access services?
That's a really good question. And it plays into a little bit what I hope to cover in this slide. So it's coming at a really a good time. I will note that there is a difference between a medical disability and an educational disability. So just because a child has ADHD does not necessarily mean that they have an other health impairment as defined under the IDEA. It's certainly very helpful to have that medical diagnosis. And I think it's, for stakeholders who are working with families, it's really important to, make sure that that is shared with the school and that the school is mindful of it and aware of it. Potentially that child might need other things like a health plan or something to make sure that they're getting their medication. But if, for example, that child has ADHD and their symptoms are very well controlled with medication, that might not be a child who has an educational disability under IDEA. It may be a child who has a medical disability, but not necessarily an educational disability, and therefore they need special education services. So that's something to keep in mind. There as well. Let me pull up the. Another thing that I wanted to point out too, in line with that question, is what is on the slide here, which is that, when we're looking at eligibility for special education, first you look at the definition for disability, then you look at whether or not that disability adversely affects educational performance. And when we look at educational performance, we're not just looking at academic performance, we're looking at functional performance as well. So if that child has really good grades, but because of their disability, maybe they have a behavioral health disability, they have some issues with functional performance. Maybe they have some issues developing coping skills or socialization. those are functional performance concerns that are just as much a part of educational performance as academics. And I think schools get that confused sometimes. I think they just focus on academics, and that is not the purpose of IDEA. The purpose of IDEA is to include functional performance as well. Now, that doesn't mean necessarily that all of the child's needs are encompassed in the IDEA. So, for example, when a child is receiving occupational therapy services in school, that's going to be different from the occupational therapy services that they're going to get through a medical provider outside of school. But that doesn't mean that that child doesn't need functional performance supports and services in school as well. So they may need some occupational therapy supports to help them access the general curriculum and help them access services in school. So I hope that answers that question, but I do think that that gets lost sometimes for folks, and functional performance is just as important as academic performance. And then the other thing that I'll point out too is that in eligibility for special education, a lot of times I hear this a lot, and I actually hear this a lot in Richmond public schools, that even though a child has a disability that adversely affects educational performance, the next step is, due to this adverse effect, the child requires specially designed instruction. I hear that, sometimes Richmond will say, well, yes, we have a negative impact on their education performance, but they don't require specially designed instruction. I find that very frustrating, because clearly the solution, if they have a disability that's adversely affecting their educational performance, clearly they require some specially designed instruction. So I just encourage folks to push through and look at the practical concerns there. What is the solution? And the schools have an affirmative duty to ensure that that child's receiving supports and services. So let me push. So, okay. So just some tips for stakeholders and providers, some things that I think it's good for you all in particular to know and to be helpful for parents as they're moving through and navigating this process. Remember the difference between a medical disability and an educational disability. It's still really important to flag for schools whatever medical diagnoses that children have. There may be some things outside the special education process that child needs, for example, like a health plan for medication. But that doesn't mean, again, that medical diagnosis is not useful in this process, just recognizing that difference. Parents can and should present external evaluations to schools and eligibility and IEP meetings, and IEP teams must consider these in their decisions. So any external evaluations that a parent receives, for example, if they receive an evaluation from VCU, VCU Health about something that their child's experiencing, they have an evaluation. It's not something that the school did, but it's something that you all did. That evaluation can be extremely helpful in this process. And so those evaluations, the parents should definitely share them with the school, and the school has to consider those in their decision making. Doesn't mean that they necessarily have to go by everything that the evaluator recommends, but they have to consider them, and they have to show how they're considering them in their decisions. The other thing that I wanted to note is that the most useful external evaluations include information on how children's diagnoses affect their educational performance, and really specifics about the services and supports that schools should consider implementing. So the more specific that you can be in evaluations about the services and supports that child needs, those are the most helpful things. Things that are recommendations that are more vague or not specific to the school environment are less helpful, because the school generally will use that to say, well, we're talking about the educational environment, not the general environment. So anything that can be specific to schools is really helpful in this process. I wanted to flag, I get several questions sometimes from folks about, okay, there's all these different services that schools can provide. There's, the schools offered this reading program, they've offered summer school, now they're talking about a 504 plan, now they're talking about IEPs. What is the difference, and what are the different things that I should keep in mind? The thing that I tell folks is, when you look at this pyramid, the most rights come with IEPs. And the least amount of rights come with the general services, and 504 is somewhere in between. And I think that that's the easiest way to look at it. For 504 plans, I really just think of those as an accommodation plan. So for example, this is a great plan for a student who is in a wheelchair but doesn't have any sort of behavioral issues or cognitive needs. They just are they have a wheelchair and that's it. So that student will need some ramps to get through and access the school environment. Maybe they need a different route to class so that they don't have stairs. They need an elevator. Those types of accommodations can be done through a 504 plan. IEPs are services and accommodations. So in addition to everything that's in a 504 plan, so say you've got a student in a wheelchair who has a wheelchair, but also has a number of cognitive or behavioral needs, that student should have an IEP, because that student now needs, in addition to that, those ramps and elevators, they need particular services. They need changes to their curriculum to access the general curriculum. And so that's the difference there. There's so much more to go over in that, but I think those are the most important things to cover for you all. So going back to our example, so you have a student and they've been evaluated for special education services. They've been found eligible because they have a disability, and maybe this was a child who had a specific learning disability because they had dyslexia. So that would be a specific learning disability. And now you are, okay, so we figured out what the issue is. Now, what are we going to do? And that child will receive an individualized education program, an IEP. Again, there's lots of things that I could go over in an IEP, but I just wanted to flag some important tips as you as a stakeholder and as you're talking to parents about this process. Some things to keep in mind. Be okay with spending time on this document. I think that usually the practice for schools is to write it before the IEP meeting, and then they spend 30 minutes going over it with a parent in a meeting and then hand it to the parent and say, sign this. This is a really important contract with the school, and it should be as complete as possible. The school should list all of the needs in the IEP of the child. They should include information about any external evaluations that were done. So if you all had an evaluation that you did and the parent presented that to the school, that should be included in the IEP. There's a portion of the IEP where you talk about present levels of performance. That's very important to include as many needs as possible, because that's useful later when I'll talk about the discipline portion. So it's just really important to spend lots of time on this document. And it's okay to ask for multiple meetings. If you don't finish and the school doesn't have time, say, well, we need to come back and have a second meeting for this. It's okay to spend time and to push for more time from the school to get it right. Review the child's record and evaluation. What areas does the child struggle in? How does the child learn best? These are questions that should inform the development of the goals in the IEP. So with an IEP, you have the present needs, and then you have goals and accommodations. So goals are, for example, if you have a child who has issues with reading, it might be this child will read 4 out of 5 passages and be able to answer a series of comprehension questions with 80% accuracy. That's a very measurable goal that the person who is working with that child on that goal can keep track of it and help that child make sure that that child is meeting that goal and progressing, because it's very measurable. It's not just this child will learn to read better. It's much more defined and specific and measurable. So those are the types of goals that you might put in an IEP. You want to make sure that it's covering multiple areas. So for example, a child who has dyslexia, they might need a phonetics goal. So they might need something to actually help them sound out the words so that they're actually doing the function of reading, but also that they have comprehension goals to make sure they're actually comprehending what they're reading. So you want multiple things to cover the various aspects of what the child really needs in this process. And finally, the special education and related services that are in an IEP should help the child to achieve annual goals and access the general curriculum. So all of this is helping them both with their special education services and, to the greatest extent possible, helping them access whatever is in the general curriculum that children in a general education classroom is receiving to the extent possible. Let me stop there and ask if there's any other questions. Okay, I don't see, okay. So I wanted to go to a second example. So we just went through one that was a student who didn't have an IEP. You worked with a family on helping that child be found eligible for services. You went through the evaluation process, and you know, that's one example. But say you have a student, and I imagine you might see this as well. You have a student who comes into the MLP who has an IEP already, but the services in place are insufficient to meet their needs. And the parent has tried to meet with the school about this, but isn't getting anywhere and has asked you for support. What can you do and what should you tell her? This is something that I see quite often. So a parent might be trying and just not getting anywhere with services. They know that the child is not progressing and they are just not sure what to do next, and they've come to you for help. These are some tips that I recommend for anyone doing any sort of special education advocacy. First is to document all concerns in writing. I think that a lot of parents are like, well, I've tried to talk with the school about it. Documentation really helps build a case, and it helps in resolution later if they need to move to that point. It also, I think, makes the school take advocates and parents more seriously. And so I think, you know, documentation is always really important. So if a parent has concerns that a child is not progressing, they should make sure that that is documented in writing with the school. I think being present and active at all of the meetings and requesting very specific services. So if a parent sees something and they're like, this is something that I see that my child needs, and I need to request something very specific, you know, requesting something very specific is really useful. And I'll talk about this in a little bit, but you want to make the school justify why they're denying whatever it is the parent is asking for. And very specific request helps the parent, because I think it's harder to make those denials. It's harder to justify why they don't need something very specific like that. The other one, another tip that I would suggest is using progress reports. When a child has an IEP, the school is required to give progress reports on their progress towards those specific goals that are in their IEP and on a regular basis. And so they should be documenting whether or not that child is making progress in their IEP. I think that those progress reports get missed a lot in advocacy. They're very useful. And if a school is not providing those progress reports, that is a clear violation of that child's needs under IDEA. They have to be documenting that progress, because that's the only way that we're going to know whether or not that child's successful. So making sure that the parent has those progress reports, that they're getting them on a regular basis, and using those to show a lack of progress or not is really important. I also see sometimes that progress reports may be inaccurate. Maybe a goal is vague, and a school is saying, well, they're making sufficient progress. They're making sufficient progress. They're making sufficient progress. You can use that to, when you have that situation, I think having other evaluations, external evaluations showing the lack of progress is also very important. So schools have to ensure that students are able to make meaningful progress. Another tip is remembering that parents can record IEP meetings and bring other stakeholders to meetings. So this is something that's helpful for you all. Schools should not be denying parents the right to bring other stakeholders who have knowledge about their child's disability to these meetings. They have to do that. If the parent wants you there, the school has to let them bring you into these decisions and these meetings. And remember that too, that parents can record IEP meetings. I usually recommend that parents tell the school that they're going to record, and the school usually likes to record as well. I think it makes the school a little bit more on their toes and a little bit more likely to adhere to the formal processes that they should. So I always record every meeting that I'm in. Schools now know if I'm coming, I'm recording, and I just make it my practice to do it in every meeting. Again, just being specific, also using the law. I think this is something that parents are, and folks who are not attorneys are afraid of, but when you can point to a law that parents are not following, or that schools are not following, parents and advocates it can be very useful in saying, okay, school, you're not doing what you should. And I think schools want to follow the law. And so if you're able to point them to something really specific, that can often be really helpful. And you'll see in a few slides, I have some citations. It's okay to look those up. You don't have to be an attorney to point those out and bring them to the school and say, look, this is something that's really clear in the law and you should be doing this. Again, you should always talk to an attorney if you have specific questions about it, but lay advocates can definitely use the law and advocate for folks in special education. And so I encourage folks to use that. And finally, I'm going to cover this in just a minute, but make sure to get a prior written notice for every single decision that the school makes. If they deny a request for services, if they deny eligibility, if a parent makes a request and saying, I want an IEP meeting and the school denies this, make sure to get a prior written notice. And I'm going to cover what that is exactly, but make the school justify why they are denying this request. And I think that's one of the most important things you can do, because if you ask for those, it puts the school on notice that you know what you're doing, the parent knows what they're doing, and they are going to have to justify whatever this is. And I think that's really important.
Cassie, we did have a question. Where do we find the law? Will you be providing like relevant sites as part of your presentation?
Yeah. So most of my slides have citations on them. So you'll see for the prior written notice, there's a citation. What I also was going to do, Allison, is I was going to provide, this is a significantly shorter presentation than the one I usually give to the MLP attorneys, but I can provide the MLP attorney one too. Again, I encourage folks to look up the law and use it and present it to schools, because a lot of times they may not know it, and so it's an important advocacy tool.
Yeah, and also these are the Virginia Administrative Code sites you can just Google and find online, right? Okay.
Yes. Yep. So again, the prior written notice, I think this is one of your most important advocacy tools, because I think a lot of times parents will request something and schools will say, no, we're not doing that, but they don't actually go through the proper process to deny whatever it is the parent is requesting. And without the prior written notice, it's very difficult for the parent to determine or to move forward on that. Say they wanted to file a complaint, or they wanted to file a due process, any other sort of dispute resolution. It's very difficult to do without the prior written notice. So I always tell everybody, if a parent denies any request, make the school justify that denial in a prior written notice and give that to the parent. And they have to do that. And I put the code site in there. So a couple tips, again, just thinking about stakeholders and the specific role that y'all might play. I encourage you to focus on attending the meetings where there's a million meetings. There's going to be, if a child is found eligible for services when they're in elementary school, there's going to be meetings upon meetings every single year. You could go to 1,000 different ones, particularly if it's a child who has really intensive needs, and those needs are changing depending on lots of different things. I would focus on attending those meetings where really important decisions are being made. So eligibility meetings and IEP meetings where the parent is making some very specific requests. You can play an incredible role in those meetings, to have someone there who is credibly saying this child has intensive needs, and backing the parent up on that can be a very powerful thing that you can provide. So to the extent that you can do that, that's always very helpful. Another thing that you can do is assist the parent in outlining the child's lack of progress, focusing as much as possible on educational performance. So again, looking at those progress reports, if in your services you're seeing issues with the child's lack of progress, that you can point to a lack of progress in school, that's something that's also really important. I also encourage the parent to be their child's advocate. I think a lot of times as advocates, we want to step in and help and sort of take over. But I always try to remember that I'm there for a blip in this child's life. And my job is not just to advocate for this child in this moment, but to coach the parent on how to be an ongoing advocate for their child in the future. So to the extent that you can help the parent build those skills and these skills to be their child's advocate, I think that's really important. And finally, letters and evaluations can be really helpful. So if you see ongoing concerns, helping the parent by writing a letter is really important, and having them bring that to some of these meetings, I think is also very useful. Just looking at time, I'm not going to go over all of these timelines. I will just point out a couple of things. Just paying attention to calendar versus business days. There's some of these where it's business days and some of these where it's calendar days. And this just goes through the specific timelines for the entire process, the initial referral, eligibility, IEP, review of IEPs, reevaluations, and then dispute resolution. Finally, if a parent, so you've tried all these things, it doesn't work, the parent is still just not getting anywhere, there's a couple of things that the parent can do. If you disagree with the child's IEP or placement, the parent can sign and indicate where they disagree. So for example, they can sign the IEP and then just say, but I disagree with blah, blah, blah. The other thing that a parent can do is they can not sign it, but follow up immediately with a letter somehow. There's a lot of issues with this that we should probably get into, but we won't have time today. So if you have something where you're having some questions about a parent signing an IEP or not signing an IEP and the consequences of that, please feel free to reach out to me. I'm happy to try to help walk you through that. But just know that that does sometimes have some consequences to it. I think it is important for parents to indicate what they disagree with. So if they really fought for something and they didn't get it and it's in the prior written notice and they're not planning on pursuing it, but they want to preserve it for later, it's okay to note that in the IEP. Finally, if it's just not working, you're trying, you absolutely need to go through the next step. There's several different things that you can do with the Virginia Department of Education. You can file a complaint, you can ask for mediation, you can request a due process hearing, which is basically like a trial. It's an administrative hearing, but you present evidence and you have an impartial hearing officer who hears the case. And you can also request an informal resolution. All of these are done through VDOE. I will note that I hear lots of issues with the dispute resolution process through VDOE. There's actually a lawsuit right now against VDOE for some issues there. And so I don't discourage parents from doing it, but I also want them to be, I want to be realistic with parents about how fruitful some of those things are going to be. So I don't think it's not useful, and we can definitely encourage families to do this and certainly can be helpful, but just recognizing some of those things may not always be as helpful as we would hope them to be. So moving to school discipline, I just want to flag a couple things with school discipline. Again, there's many things that we can talk about. So when I say school discipline, of course, I'm talking about a child who gets in trouble in school, something happens and they get in trouble in school. How the school disciplines that child is dependent on whether or not that child has an IEP. So for example, if you have a child in school and you have two children in school, they both have ADHD, but only one has an IEP and the other doesn't have a 504, they don't have anything, they just have ADHD, the process for disciplining each of those children is different. So just wanted to clarify that, or it can be different depending on the discipline that the school's implementing. I wanted to flag that all children in school are entitled to due process rights if they are having some discipline happening. If discipline is occurring, they're entitled to some due process rights. So if the child is facing a suspension, for example, for 3 days, that child is entitled to some due process rights before they're deprived of their educational services. Usually it's notice and a right of appeal, a right to have some kind of meeting. It's something that I think is not always understood. And so just important to recognize that there are some things that schools need to do in order to discipline students. I mostly wanted to flag what happens for students who have disabilities. So say you have a child who, because they have behavioral health concerns or something else, they are being removed from school quite often. And I will note that what I hear a lot is that schools will call the parent to pick them up, but they're not necessarily being suspended. I call that, it's an informal removal or an informal suspension, but it's still a suspension. The school, and so what I always tell parents in that situation is, ask the school if your child is being suspended or not. Is my child being suspended or not? Give me a notice of it. If not, then you have to continue, educating my child. I need or ask for an IEP meeting or ask for special education services to deal with whatever the school is experiencing if it's a common occurrence. There's some duties that the school has in order to try to resolve that. So if it's a removal for less than 10 days, say you've got a student who has a series of suspensions, it's 3 days, 3 days, and 3 days, but overall, cumulatively, it's less than 10 days. That student is just entitled, and that student has an IEP, they're just entitled to the due process considerations that's afforded to all students. However, if you have a removal that's more than 10 days, say you have a student who has an IEP and they are being suspended for 45 days, the school must provide due process protections afforded to all students, plus a manifestation determination review hearing, plus services during removal. So I'm going to talk about what the manifestation determination review hearing is, but I think it's one of the most important things that you can know about as an advocate for children with disabilities. I wanted to mention too, I think a lot of schools do not necessarily take into account when removals are less than 10 days, but cumulatively over the school year, it's more than 10 days. I would advocate that at the 10th day that they've been removed from school, that they are entitled to a manifestation determination hearing. So I would push for that. If you have a situation where a child is having lots of short-term removals and overall it's more than 10 days, I would push for that. A manifestation determination review hearing. So for example, say you have a child who they get into a fight at school. You've got a child who has behavioral health needs and they have an IEP for an emotional disability and they get into a fight at school. And very clearly in their IEP, it talks about their impulsivity, their their lack of coping skills, those types of things. And so then they get in this fight at school. They've been suspended for 45 days. The school is required to have this manifestation determination hearing or an MDR. So this is a meeting with the school and 3 different questions are asked. Was the incident caused by the child's disability? Was the conduct directly and substantially related to the child's disability? And 3, was the conduct the direct result of the school's failure to implement her IEP? And if the answer to any of these questions is yes, the school cannot change the child's placement without parental consent. The school must return the child to school and they must do a functional behavioral assessment or a behavior intervention plan. Those are other plans that the school might do to help a child who has behavioral health needs. I hear a lot from schools that he knew what he was doing, she knew what he was doing, therefore it wasn't a direct result of their disability and therefore, we're going to deny the MDR. That is not the standard. The standard is whether or not the incident was caused by his disability. My strongest tip for MDRs, and this is why I think one of the reasons that I think an IEP should be so complete and so thorough, is if you document in the IEP that child has impulsivity and a lack of coping skills, and that is what you can point to as a cause for the fight, why they got into this fight, use that IEP to link the disability and whatever the behavior that occurred, and encourage parents to do that too. So whether you're attending or, encouraging the parents, to attend, those types of tips can be helpful. And again, make sure that whatever the school's determination is in a prior written notice that specifically says why or why not they're agreeing that it was or wasn't a manifestation of the student's disability. Let me pause. Is there any questions in the chat, Allison?
We have one actually from the last section about progress reports. The question is, how often are schools required to provide progress reports, and does this entail a meeting with parents?
It does not entail a meeting. It's however often that other students receive reports. So usually it's every, how students usually get 9-week report cards and various progress reports. Every time that students who are in general education receive progress reports, the school should be providing progress reports on that student's IEP goals. So that's however often in the state that occurs.
Thank you.
Yeah,
That's it.
Cool. Just reminding folks that if a child with disabilities is removed for a suspension or whatever, or an expulsion, services during removal must start on the 11th day and must allow the student to make progress on their IEP goals and participate in the general curriculum. So that student has to be receiving services in the meantime at day 11. One more thing that I wanted to bring up is that discipline deadlines are really short. So if you hear about a child who's been suspended or expelled, usually the deadline for responding to those can be 3 to 5 days. They're extremely short. So just reminding parents, if they have a child who is facing a series of disciplinary actions, to respond to those immediately. They should be in the notices that the parent receives, but just making sure that they understand the deadlines to respond to those. If a hearing is held, it is really helpful to have stakeholders there to talk about the child's positive qualities. So this is something where you all can play a really positive role in this process. If you can't attend in person, having a letter there can be really helpful. But you all writing those letters or being present in those to talk about the child, helping the school board or the disciplinary officers see the child as a whole person rather than just this behavior is really important. One more thing that I'll note about this process is that the MDR and the discipline hearing, totally separate. You can bring up the disability in the discipline hearing, but they're totally different processes. So just flagging that. Okay, I do want to make sure to get to the bullying, because I know this was something that Allison said that y'all are hearing about a lot. And so wanted to talk about what to do if you have a parent coming to you who is having a child who's being bullied. So again, you have a child who comes to you. She has a daughter who's maybe in middle school or high school, and her daughter is disabled and she's being bullied in school. She's experiencing bullying both in school and online via social media from students at school. And the parent has spoken to the school about this, but nothing is being done. And in the meantime, her daughter is struggling with social isolation and depression. What can you tell her to do? So bullying is really hard. And I think schools, even though there's been a strong push, I think in the past few years to address bullying and for schools to address bullying, I think a lot of schools still are not totally sure what to do, particularly in cyberbullying. Like in the example that I just talked about, a lot of schools will want to say, well, that's off-campus behavior that we don't have any control over, which is not actually what is in most of the guidance documents that I included here. I think the most important thing is documenting concerns. Again, that's always going to be one of my strongest tips, is documenting concerns. If the child has a disability, like in the example I said, adding an IEP meeting to add functional and social goals to her IEP. So if she's struggling with depression and socialization, she's becoming more and more isolated, that should be addressed in her IEP, because the bullying is now affecting her functional performance in ways that may not be currently addressed in her IEP. So those should be accommodated and specifically addressed now. So ask for an IEP meeting. ask for a separate meeting with the school to develop a plan to address the bullying. So this is a meeting with the principal, counselors, anyone else in school. Maybe that plan is going to say that the student is going to change classes, or there's going to be specific plans in place to keep the student separate from the students who are bullying her, plans to make sure that teachers or other adults in the school who are going to come into contact with the students who are doing the bullying and the child who's experiencing the bullying are aware of it and have a plan in place to address it if they see it. Communication, I think, is going to be really important. Another thing that I use a lot is the model guidance on bullying. So I linked it here down at the bottom. And again, I'll make sure that I share these slides with Allison, but using this model guidance from the Virginia Department of Education. If the school has not developed their own model guidance on bullying, being able to use this to show this is how VDOE expects you to respond to bullying situations. This is an example of something you can do. There's a lot of good tips in there. So using that model guidance. Ensure that if cyberbullying is occurring, that is documented. So saving all texts, social media posts, et cetera, that demonstrate how the bullying is impacting the student at school. So if it is something that is happening off campus, but that student is being impacted at school, say that they received a threat at over social media at home, and then that student goes to school the next day and is going to see those students who made that threat, that's impacting them in school. That is having an impact on their education at school. And so that's something that the school needs to be addressing. So being able to affirmatively make that link between home and school. And then if all else fails, my suggestion is to send something called a Gebser letter. This is a legal letter that puts the school on formal notice that the bullying is happening and asking that it be resolved. I strongly recommend doing these other things first because you want to include what actions you've already taken when schools send a Gebser letter. You don't have to be an attorney to send this letter. I will send Allison a sample Gebser letter so that you can share that with your families. But I think it's an important tool to be able to use, and it shows schools I'm taking this seriously, and I want you to as well. So we are short on time. I did just want to flag a couple other things. I'm going to try to do it in a couple minutes, but I just wanted to note immigration status and language access. Schools must enroll students regardless of their immigration status and can't require parents or children to disclose their immigration status, but they should ask them about their language that's spoken at home so that they can offer them the appropriate language services. There's a lot of rules, there's a lot of laws about language access and what schools need to be doing to ensure appropriate language services for families. And I put a link to a really great series of federal documents on that if that's something that you are seeing and you need more information on. OCR complaints, they're really easy to file. This is a complaint, a civil rights complaint to the U.S. Department of Education. If you think a student is experiencing discrimination, this is a very easy form to fill out, and I encourage folks to use it. It's just because they're so simple to file. Finally, I wanted to flag that children who are experiencing homelessness have a very important series of rights under the McKinney-Vento Act. This is separate from IDEA. This is another education law that is just a wonderful one, in my opinion. And it ensures that children who are experiencing homelessness have as much stability as possible in their education plan. So really what it usually means is that students who become homeless during the middle of the school year, they have an opportunity to continue to attend their home school, even if they go to a different school district in the middle of the year. And there's some specific laws and rules about transportation services that schools have to provide and work together to provide, all to ensure that that child experiences as much educational stability as possible, even as they are experiencing significant housing instability. If you have any issues with children who are experiencing homelessness, I strongly urge you to contact Project Hope Virginia. It's at the College of William and Mary, and they are the designated state agency to ensure that children who are experiencing homelessness receive the services they're entitled to. So I put a link to their website in there, and again, highly encourage you to contact them. Finally, one more thing is that if you have a parent who has been trying to get their child's records and they just have not, remind them that they do have a right to access those records. And I just put a link to some more information about this particular law. But I hear a lot from families that they're having trouble accessing their child's education file, and I always remind them they do have a right to access that. And so referencing that law in their request for the file can sometimes be helpful. Again, I included some additional resources there. I also am sharing my email and phone number. If I didn't get to any questions that you had today, please feel free to contact me. I love this area of law. It's definitely one of my favorites, and I'm very passionate about it. And there are, as you all know, just a dearth of people who are working in this area. And so I'm always happy to share. I learn so much from the questions that I receive. And so always welcome any questions at all, and I will try to help as much as I can. Sometimes I get so many that it takes me a little while to respond, so I apologize in advance if I'm a little delayed. Please feel free to email me again if you don't hear from me, but I always want to hear from you all. So before we finish, I did just want to say thank you all so much for the work that you do. It's just amazing having stakeholders who are invested in this process, invested in the children that you're serving. So I just really appreciate you all. I really appreciate Allison for letting me come and share this information with you all. And I hope it was helpful.
Yes, thank you so much, Cassie. It was really, really thorough and fantastic. Lots of comments in the chat thanking you, that this was just a huge help to everyone. And so we really appreciate your passion and your expertise and always being willing to answer our questions. So thank you so much. Lots of requests for the slides. So, so I will be sending those out with a recording next week. Thank you for sharing your contact information. And thank you everyone for joining. I want to echo Cassie's sentiment. We thank you so much for your advocacy on behalf of your patients and for reaching out to us. And we hope to be able to have more attorneys available very soon, and we will let you know. So thanks everyone and have a great day.